Hello, everyone, and welcome back to the.universary. Today's small claims cases are in front of Judge Brett Buckley and Judge Jeffrey Middleton. This first one is Judd Sherman, DDS, versus Marcy Maza. And Miss Maza is claiming that Dr. Sherman was her dentist and he made an error that resulted in her losing nerve function in a portion of her mouth. And this is that case. I hope you enjoy.
All right, I have reviewed what's been filed in this case. And first of all, is it Dr. Sherman?
Yes, correct. I'm a dentist.
All right, so you're a dentist. Okay, thank you. And Ms. Maza, I've read about the anesthetic, the shot that you received, and the nerve damage you're complaining of. I've read the file. Anything else you want to add to what you have in there?
No.
Okay, so just to summarize, it's your belief that the ongoing issues you've been having or currently have, I'm not sure whether you currently still have that, are as a result of an action by Dr. Sherman. Is that right?
Yes.
Okay, and what do you think that Dr. Sherman did wrong?
The first thing is the injection. And Dr. Werner stated that in order to hit the nerve that was damaged, it was very deep. And the second thing is that I was never offered going to a specialist. And I believe that the time lapse, because Dr. Sherman said that there was a time with microsurgery that was offered to me that has to be met in order for a successful surgery. And that time was passed by the time I got to Dr. Werner. Secondly, I do want to know.
Excuse me, I think she just said Dr. Sherman, but I didn't tell her.
I'm sorry, Dr. Werner. The specialist, okay. Dr. Werner. Okay. I apologize if I said Sherman. Also, I do want it noted that in the defendant's, Dr. Sherman's notes, that the medical records have been altered. And with the alteration, he states that he offered me a oral surgeon to be sent to an oral surgeon, which to me, he knew that I should have seen one, either at the time of the appointment for the extraction or when I came back to see him on the 17th with my symptoms.
Okay. And Dr. Sherman?
Yes, I have some stuff I wrote out. You mind if I say it?
Go ahead.
Okay. Good morning, Your Honor. I am Dr. Judge Sherman. And although I am sympathetic to Mrs. Maza for the pain she has experienced, I am adamantly dispute the allegations in her complaint. This matter concerns dental treatment I provided to plaintiff, and plaintiff's claims should be dismissed for the following reasons. As the documents show, the plaintiff's claim for the dental injury / negligence lacks merit. I advised the plaintiff of the risks concerning the tooth extraction procedure at issue, and the plaintiff signed a detailed consent form acknowledging the risks, the complications, and side effects of the procedure, including numbness of the tongue. And that's in the consent form. You probably have it.
I do.
Also, I performed the tooth extraction procedure in accordance with my training and experience, with no perceived complications at the time. Also in the patient's chart notes, I also said that it went as planned and no complications. In sum, I complied with the standard of care of a reasonable, prudent dentist by advising plaintiff of the risks associated with the procedure and by competently performing the work. Moreover, the plaintiff's claim lacks merit because it requires expert testimony from another dentist to prove that the treatment I provided fell below the standard of care. The plaintiff has no such expert opinion, and therefore her claim fails. Further, even if a court ultimately overlooked the plaintiff's lack of expert opinion, I complied with the standard of care of a reasonably prudent dentist, and therefore the plaintiff's claim fails. The plaintiff's claims fail because 1, I complied with the standard of care, and 2, it requires expert testimony, yet plaintiff has not provided any. I complied with the standard of care by advising the plaintiff of the risks associated with the procedure and by competently performing the work. I have had extensive training to become a dentist. I'm a dentist for 23 years. I routinely extract teeth daily. I routinely give all types of injections. Also, the surgery, the consent form was signed by the plaintiff, which discussed the risks and complications, which in this case, specifically the risk of nerve injury, potentially permanent numbness. Also, you have the before and after x-rays are provided and further indicate the procedure went routinely. And then also, I just want to point out when the patient came in, this is in the notes, that she had pain, swellness, numbness, and vertigo at the initial appointment. The plaintiff lacks the requisite expert testimony to prove her claim. The general rule is that the expert testimony is required when an essential element in the case is best established by an opinion which is beyond the expertise of a layperson. And this is Brett versus St. Luke's Memorial Hospital, 1987. Also, a plaintiff who seeks recovery from a healthcare provider for injuries resulting from medical treatment must, except under unusual circumstances, be prepared to offer expert testimony to establish the essential elements of his or her claim. Without this necessary expert testimony, a plaintiff cannot prevail. That's Harris versus Groth, 1983. Also, Washington courts have also established the degree of certainty to which the experts must testify in order to establish a successful medical negligence claim. Expert testimony must be to a reasonable degree of medical certainty and cannot be mere conjecture or speculation. That's Rounds versus Nelcar, 2008. In addition, the expert must be able to testify that the standard of care violation, more likely than not, caused the plaintiff's damages. That's Merriman versus Toothager, that's 1973. Here, it cannot reasonably be disputed that expert testimony is required to establish the standard of care and causation in the context of dental malpractice. It is not within the common knowledge of a layperson to determine, 1, what the standard of care is for the dental procedures performed on a plaintiff, and 2, whether any act or omission during the procedure caused the plaintiff damage. The plaintiff has failed to produce competent evidence through expert testimony. 1, I violated the applicable standard of care, and 2, any act or omission during the procedure caused the plaintiff damage. The plaintiff has presented letters and records from Dr. Rakow and Dr. Werner. However, they provided no opinion that my treatment was below the standard of care in any way. In fact, the plaintiff has presented no opinion or letter from a comparable expert regarding the standard of care I provided to the plaintiff. This failure requires dismissal of the plaintiff's claim. For all these reasons, the plaintiff cannot prove her claims, and I respectfully request the courts dismiss those claims with prejudice.
All right, thank you. And Ms. Mazza, anything else you want to say?
The consent for care does not include injury. It's irrelevant. And as far as submission of testimony from an expert, I provided documentation from Dr. Werner regarding what his diagnosis is. I provided letters that he provided to Dr. Raquel for the referral that states that I suffered an injury from Dr. Sherman. And I also have referrals that I included that state what I sustained and from my local dentist, from the dentist. I'm in small claims court. I'm here because I can't afford an attorney. I'm here because I can't afford to pay for expert witnesses to be present in a courtroom. And that's, I'm gonna leave it at that.
All right, thank you. Okay, this was the case I had in mind when I was making the comments prior to beginning, that I have to decide the case based on the law and not based on, what the equities are, as we call it, or, basically who's right or who's wrong, who suffers pain, who doesn't. And in reviewing the pleadings before the case and hearing the testimony now, nothing's changed from my initial view of it, which is I read the records submitted by Dr. Raquel and also Dr. Werner, and neither physician or dentist, rather, indicates the cause of the injury. They acknowledge the injury and talk about attempting to deal with the pain. Dr. Raquel, in fact, mentioned in one of his notes that hitting a nerve can happen. So he recognizes, or he's making that statement as, yeah, sometimes that's what happens. And I know that was in some of the procedure disclosures by Dr. Sherman that you signed, Ms. Maza. And then looking at Dr. Werner's statement, Dr. Werner indicates that one, he says, I do not feel that an immediate evaluation by a peripheral nerve surgeon was warranted. And that really goes more to the depth of the injury. But apart from that, he goes, speculating on the cause included a local aesthetic injection injury. But he doesn't tell us whether, he says it's very possible that the injection caused the injury, but he doesn't say the injection done by Dr. Sherman was in any way negligent. So it's not just what was the cause of the injury there. It has to be that Dr. Sherman was negligent in creating that causality. And in this case, there's no statement here other than the fact that you were injured and you suffer this pain, that Dr. Sherman did anything wrong. He hit a nerve, and according to both Dr. Raquel and the documents that you signed for Dr. Sherman, that's a potential result of the procedure that you underwent. So without an opinion that Dr. Sherman did something wrong, not that I think everybody sort of thinks that, yeah, the injection caused the injury. He has to have been negligent in the injection, and there is no statement from either doctor that there was negligence. And so based on that, I will have to dismiss the claim.
Understood.
All right. Thank you both.
Thank you for
so
your
much.
time.
Yes.
Okay, now this second case is out of Michigan. We have SNR Kalamazoo, represented by Matt Ludeman, versus Cassandra Burton. And this is a case where a grant program was utilized to install a fence in Ms. Burton's home, or around her home, as she was doing an at-home daycare. And she says that it didn't quite work out. The grant program was supposed to pay for it, but the contractor didn't get paid, and who's on the hook. Hope you enjoy.
SNR Kalamazoo, doing business as Superior Fence and Rail of Southwest Michigan. And Mr. Matt Ludeman is here on their behalf, and Cassandra Burton is the defendant. Mr. Ludeman, what's your position with that company?
I'm the owner, president of the company.
All right. And will you both please raise your right hand? All right, let me make some notes here. This is a claim for $2,248.88. Ms. Burton had some sort of a program that has assisted people in getting home work renovations done. And they had a contract with SFNR, Superior Fence and Railing. However, the plaintiff claims that you made several job changes which were not approved by the grant, and there was additional cost in the amount of $2,248.88. Is that correct, Mr. Ludeman?
That is correct. On June 7th, 2023, we were installing her fence, and she wanted to add an additional 40 feet of fencing. So where we provided her a change order that had our contract essentially built into it, and it shows clear as day saying that that if she approves this change order for that price, that we would get paid for the additional amount of fence put in. She was using the IFF contract, which was a grant money set aside by the state for daycare facilities to put in fencing around their facilities, so to speak. And then post install, I believe she found out that IFF wouldn't cover the change order portion that she signed off on June 7th, 2023.
All right, Ms. Burton, what's your position?
Yeah, so I partnered with the IFF, and the person that originally came out and did measurements and stuff like that, upon arrival, he didn't put the correct measurements that we wanted done. Like, he wanted to go in front of trees and instead of behind the trees. So the person that I worked with was very nice, and he said that we could change it up, and I submitted the change to the IFF. And matter of fact, on the last page of this paper that I have here in this packet, it says it looks like the cost adjustment was approved. So that's good. So to my understanding, my cost adjustment that I had made was approved by the IFF, and I didn't know that they declined it or whatever happened in the process until months later. Now, in the meantime, I don't live there. I've been through a divorce. We've lost the house. I live in a government funding apartment. I'm 37 weeks pregnant. I'm about to go on maternity leave. I won't have an income. It's not paid. I'll be getting cash assistance. And I'm sorry that this happened. I really am. But I was under the impression that it was taken care of because it said it looks like the cost adjustment was approved. So that was my impression.
All right, the problem is I'm scrolling through dozens of pages of documents in typical government fashion. There's a very lengthy contract here, but I'm trying to get to the actual change order.
It's the one that's dated for Tuesday, August 15th from Gail. It looks like, I don't know if you probably can't really see, but it looks like this. It was the last page in my big, thick paper that I got. I don't know if you have the same one, but it should be the very last page.
Well, once upon a time, I had a paper file and I could just flip through the pages, but now I have to scroll. Try to get to the bottom. I've been contacted by Superior Fence for support so they can receive their final payment for the work they did for you. There are still some steps that need to be completed. I'm copying and pasted the response I got from IFF regarding your project. You could follow the guidance given. Superior will get the final payment. I'm also copying Aaron from Superior Fence on this so they are aware their payment will be processed once the steps below are completed. So what you're saying, Mr. Ludeman, is that they never would pay the final change order?
IFF paid the final balance of the original contract. So we asked for 50% down and 50% upon completion of the fence. But IFF, we were back and forth with the IFF on this as well. Aaron Brinks was the person working on this on our behalf for the company. And they said that they would not, that the original contract that she signed was for the $13,535.40, and that is what they weren't able to change that from when she first had signed it. I guess I don't know when that was, but I'm guessing probably May or April.
I'm sorry. And then the second one where she included the email from IFF right below what you just read, it says it looks like the cost adjustment was approved, which is under the impression that I was, because I did submit the change order to cover the extra cost. And it just says that, yep, you guys haven't received the final payment because I had to go on and complete the project complete form, which I did.
And then IFF apparently declined to pay it. Yeah,
Right.
so I understand why you did what you did. It looks like the cost adjustment was approved. And this goes under the category of paying for a dead horse. You had all this done for your daycare. You're no longer there. You
Yeah.
made the improvements for someone else. Has the house been sold?
No, actually, when I went through the divorce, I signed off and gave it to my husband, and actually he wasn't able to afford it, so it went to foreclosure.
And you're presently in a position where you're not able to pay. But let's
Correct.
talk about that. This is what it is. There was a contract, there was a change order. The company didn't pay it and the work was done. So I find for the plaintiff the amount of $2,284.88. Costs are $83.50 and other, which is the service fee, is $47.30. So the amount owed is $2,415. I'm not going to do a payment plan because you don't have the current ability to make a payment. This judgment is good for 6 years. Are you at Meadow Lane?
Yes, sir.
All right. I understand why you did what you did. You asked for the changes that looked like they were going to pay for it, but all they paid for was what was in the original contract. There were drawings. It's hard to tell with the drawing without seeing actually what the topography was, but that was what you agreed to and they agreed to. And then you asked for additional service. So, Mr. Ludeman, you've got a judgment that says she owes the money, but she doesn't have any money. So you can garnish her income tax, state income tax. You can try to garnish wages, but she doesn't presently have any wages. I would set up a payment plan, but right now she has no income and she's about to go off on maternity leave. So things may change. What I would advise you to do, Mr. Ludeman, is some months from now, where are you working now, Miss Burton?
Yeah, this is my last week of work. I work at It's called, it used to formerly be Lilliput, but it is called It Takes a Village now.
It's a
It's a
childcare
child
place?
care center, yes.
And where is that?
Right across from the Dollar General here in Constantine.
All right. Well, at some point, she may be back to work, hopefully for her and her family's sake. You can do what's called a discovery subpoena. Write this down. And you can subpoena her to come to court, talk about her ability to pay on the debt. Right now, she's gonna be off doing childcare at her own house for a period of time. So that would be my suggestion, maybe in 6 months or so, do a discovery subpoena, contact the clerks. It will be a situation where you both be summoned to come to court, and we will make a finding and see if she's in the ability to pay at that time.
Understood.
All right, you'll both get a copy of this in the mail. Thank you. You're good to go.
Thank you.
Thank you.